The allegations of adultery and paternity fraud were raised by the husband.
You are saying that she's living in adultery.
She's living in adultery.
Then that has to be proved. When he wants, when he claims custody of the child, he wants to prove that he is not his child and he wants to have the custody of
He
the
has sought for divorce on the ground of adultery, Your Ladyship. She has never denied adultery or the paternity fraud. That is my argument, which I will make before
No,
the
you must
trial
have
court.
filed your objections to his MC. That you must have denied.
She's
Absolutely.
not denied, Your Ladyship.
Absolutely denied.
So that
They have not placed the GWC.
objections if you have.
I don't. I only have soft
How
copies.
can anybody not?
Absolutely.
Your
without
Ladyship,
even
that is my
looking
problem. They
No,
have not
if
placed the
not-
entire record before
Not
Your
specific
Ladyship.
denial. There would be a general denial for all the other allegations.
Wife's petition challenging an order of the family court dismissing her application for maintenance insofar as she and her son are concerned. So for the daughter, my lord, the family court passes an order for payment of educational expenses.
Let us
Yes.
see. Now, who are the parties?
Lord, the divorce petition by the wife, petition for divorce filed by the wife, she had sought maintenance for herself and for her children.
Where is that IA?
So the applications are annexure H, my lord, page 161.
160.
161.
Where do you get the parties? Are
Sorry?
the children? Only wife appears to be the. Where is IA?
No, I is 161.
160?
161. The parties, it's a petition for divorce filed by the wife. In the application, for
The IA parties for whom she is.
children are not made parties. But in the application itself, I prayed minor children, Ahalya and Ekalavya, for their maintenance and educational expenses.
That's how the procedure is.
Yes.
There. Not required.
They are not to be made parties.
Even in an IA.
Even in the IA.
Mother seeks. So and so on behalf of them.
On behalf of the
No, they shouldn't be shown as parties.
No.
What is the maintenance she sought?
No, maintenance sought was 6 lakh rupees apart from educational expenses.
I think this is the second round of litigation. Appeared
Yes,
before
your lordship dealt with the matter when it came up for the visitation and summer vacation custody. The challenge to that order was on the ground that the father had undertaken in the custody proceedings itself that he would pay the children's educational expenses and also reimburse whatever the expenses the mother has incurred prior to the decision on the maintenance application. My lord felt that it's better that the family court is directed to dispose of the maintenance application in the divorce petition. Your lordship's order is at page number 155, annexure G. The order, aggrieved by the order dated 1/3/2024, the wife is before this court stating that the father, without paying maintenance and taking care of the children, he wants visitation, and the court, without considering the same, has granted visitation. When the matter came up before the court, this court had directed both the counsel to have instructions from the clients, wherein the father will have visitation of the children and the father will pay the amount for maintenance and educational expenses of the children. On instructions, learned counsel for the father submits that the subject to further orders to be passed by the trial court on the pending application, father is ready to pay an amount of rupees 2,50,000 and he will pay 1,75,000 by 28/4 and the balance amount within 10 days from 28/4. The trial court had granted visitation on every second and fourth Saturday from 10 a.m. to 6 p.m. Considering the submission made on behalf of the father that the father has no access to the children, the court deems it
Now,
appropriate.
please come to the impugn order.
Yes. 26 is where the order starts. But 29 are the reasons. The petitioner and the wife has filed the present petition against the respondent, her husband, seeking dissolution of their marriage by decree of divorce based on cruelty. The petitioner in her petition has also sought permanent alimony of rupees 15 crores from the respondent. It is on record, even the respondent has filed MC 1487 against the petitioner, herein the wife, seeking dissolution of their marriage by decree of divorce based on adultery and cruelty, and both of them have been clubbed together. Respondent has specifically contended that the petitioner has committed paternity fraud towards him. The respondent has contended that Ekalavya is not his biological son and he was born out of the illicit relationship of the petitioner with one so-and-so, a resident of Varanasi. The respondent has contended he has obtained 3 DNA test reports of him and Ekalavya from 3 different labs in India, USA and Canada. The respondent has contended that the last so-and-so of the petitioner was 1/4/2012 and as such, for the birth of the second child, the petitioner has conceived in the month of April 2012. The respondent has contended that the ultrasound reports of the petitioner and a discharge summary make out about conceiving Ekalavya. The respondent has contended that he was completely non-access to the petitioner from mid-March 2012 till the end of April 2012 as he had gone to USA and other countries. The respondent has contended during the above said period due to some urgency of his business that on 5/4/2012 he came back to India, attended his work and on 8/4 departed to Brazil. The respondent has contended that as he was abroad, the petitioner went to Varanasi with her parents on 29/3 and came back to Bangalore on 26/4/2012. The respondent is contended as Vinamra lives in Varanasi. The petitioner committed adultery with her paramour during the said period, which resulted in the conception of her minor son. The respondent is contended that the petitioner intimated him about conceiving her son. He was dismayed and confronted the petitioner about his non-access. The respondent has contended that he has also filed petition against the petitioner seeking dissolution of their marriage by decree of divorce based on adultery and cruelty. The same is pending on the file of this court. The respondent in this objection statement with minute details has specifically pleaded about illicit relationship of the petitioner with other and also about his non-access to the petitioner during conceiving of the petitioner to her minor son Ekalavya. The respondent has contended that on 2/1/2013, the petitioner gave birth to Ekalavya, and in the year 2022, he came to know of the illicit relationship of the petitioner on going through the attitude of the petitioner towards him, and also on securing WhatsApp chats between the petitioner and her sister and others. The respondent, though in his objection statement with minute details has taken the stand about illicit relationship, the petitioner has not filed any rejoinder disputing the specific allegations made by the respondent against her. The material on record make out that the respondent has made serious allegations of adultery against the petitioner and his wife with documentary evidence. Sections 24 and 25 of the Hindu Marriage Act enable the court to grant maintenance, pendential and permanent alimony during the proceedings initiated under the Hindu Marriage Act. Sections 18 and 20 of the Hindu Adoptions and Maintenance Act.
Yes, I've seen.
Yes. Lord, my submission is, these are allegations made by him. Lord, these allegations have to be substantiated in the course of a trial. I have denied. Lord, in fact, my petition itself is that the respondent suffers from certain disorders and certain fetishes that he has. And that is a matter not for the trial court to consider at the time of trial. This order now passed is against all established principles of law, judgments of the Honorable Supreme Court, which say that otherwise, in every case, the father will make an allegation and thereafter evade payment of maintenance. And I also want to place on record the DNA reports which he has placed before the court. This is not subject to any order of the court. These DNA reports are obtained by him clandestinely. We do not even know. In fact, the report itself says this is not authentic. This is a private report submitted by sample submitted by him. We do not know whether it's contaminated with the dogs of people that he claims the DNA has been taken from. Some hair has been given as sample.
It was taken. This is marked.
He has produced along with his objection statement. Page number 1, my lord. At page number 1, at the bottom there's a box. Since the samples were not collected under a strict claim of custody or on order of honorable court by a third neutral party, and the laboratory cannot verify the origin of the samples, this test result may not be defensible in a court of law for the establishment of paternity and other legally related issues. The tested parties' names that may appear on this report have been provided by the client and cannot be verified. The lab assumes no responsibility for incorrect or misspelled patient information. Testing has been performed at CTRF and ISO so and so. They shall not be obligated to appear or serve evidence before any court of law pertaining to the testing services provided to DFL. There's one more he's produced. He's produced 3 reports. All 3 reports say the same thing. Page number 3. At the bottom, there's a note. Since the samples were not collected under a strict chain of custody by a third neutral party, and the lab cannot verify the origin of the samples, this test result may not be defensible in a court of law for the establishment of paternity and other legally related issues. The tested parties' names that may appear on this report have been provided by the client and cannot be verified. Same, the third report also the exact same thing. Therefore, acting on this, what is of significance is, until I leave the home along with the children, on 1st November 2022.
Then why is he seeking visitation of that child?
He's claiming custody. He's filed a petition claiming custody of both the children. And your lordships will remember in your lordship's order, visitation is of both the children. On one hand, my lord, he says, I want custody of both. On the other hand, he says, this child is not mine. Until we separated, my lord, every single expense is taken care of him because I am a housewife. He comes from a very big business family and he
When they separated, what is the age of that boy at that point of time?
10 years old.
At that time?
At that time. Now he's 13.
Now he is?
13 years old. 1st November 2022 is when I left the home along with the children. Until, and my lord, the undertaking given by him before the court I have produced in the custody case where he has signed, he was present before the court and he has signed. Lord, that's at page 141. Thereafter, I file an application before the court. He is violating the order. The very same judge dismisses my application. Page 141. So, page 139, I'm sorry. Page 139, may I read, my lord? Both the parties and their counsel are present with children. Conciliation held in camera from 3:05 to 3:15 p.m. I've interacted. Name of the child, Ahalya, she's 13 years old, studying at 8th standard. Name of the son is Ekalavya, 11 years old, studying at Inventure. At present, children are residing with their mother. They have no problem to meet their father, spend quality time with him, but they want to continue to stay with the mother. The petitioner is ready to bear the expenses of his children and also reimburse the school fees paid by the mother. He has signed the order sheet, my lord, on the left-hand side of file.
MC is filed on what ground?
By the wife, my lord, on the ground of cruelty. By the husband,
Husband has not filed.
he has filed subsequently on the ground of adultery.
Which year is her MC?
Both are in 2023. 990 of 2023 and 1487 of 2023.
Now, in the objection that was filed to her MC.
Yes, madam.
He has taken all the allegations.
Yes, he has made the same allegations.
Yes.
My lord, on the next page, page 141, my lord, undertaking given to the court, the last paragraph, advocate for the petitioner submits his client will pay the school fees and also arrears within 2 weeks. These are undertakings given to the court. Therefore, my lord, when I challenge the visitation order, I brought to your lordship's notice that when he has given this undertaking, it is not complying with it. He is not a person, my lord, who should be countenanced by awarding the visitation until he complies with his own undertaking. I file an application, my lord, for contempt to be initiated against him under the Guardians and Wards Act. The very same judge, my lord, who passes the maintenance order dismisses my application at page 144.
Yes.
Order on IA number 10, page 144, last 3 lines. Directly, all of a sudden, any party can't be punished and there must be some procedure for initiating criminal action. The Guardians and Wards Act itself provides, my lord, for violation of any interim order, contempt proceedings can be initiated. I file an application for securing his credit card records. That application is rejected, saying adverse inference will be drawn against him if he does not produce the documents.
Yes.
Your Ladyship, at the outset, my learned friend who is here asking for interim maintenance and maintenance has not filed any of the documents which were before the family court, which were filed by both the parties along with the affidavit of assets and liabilities, bank statements, ITRs, bank statements of the business of the respondent also. None of those documents have been placed before your Ladyship.
Because that is not required at this stage, as the court has discussed it altogether on a different ground. Not with regard
I
to
understand
the-
your, I understand your Ladyship.
You have to address your arguments only on that, whether the court was justified.
I
in,
understand.
this-
I will restrict
Yes.
that. Your Ladyship, the first petition which was filed between the parties was the guardianship petition, not then the second petition was the divorce petition which was filed by the wife. Third was the divorce petition filed by the husband. The allegations of adultery and paternity fraud were raised by the husband before she filed any divorce petition in the guardianship petition itself. Irrespective of the adultery and the paternity fraud, he has been a father to the son. He has never denied that I will not pay for the son.
Then why he wants to do all this?
Why he wants to?
When he claims custody of the child, he wants to prove that he is not his child and he wants to have the custody of
He
the
has sought for divorce on the ground of adultery, your Ladyship.
But why you want custody of a child?
He
who
has
is
been a
not
father
your-
from 2013 to 2022. He has been a father to the son and the daughter. He was not aware of any of the adultery or the paternity fraud for 9 to 10 years. He didn't discover that until November 2022. And he has been a father and he has a bond with the son. The son adores him. The daughter adores him. They
In that
are,
case, then why you don't give maintenance to them?
sorry?
Why you don't give maintenance to them?
Your Ladyship had directed in April 2025 when the petitioner had come before your Ladyship in the visitation writ. Your Ladyship had directed payment of 2.5 lakhs that was duly paid within the time your Ladyship had directed
That
in.
was only an interim arrangement.
I understand. Before that, he has also paid another 2.46 lakhs back in the year 2023 for the children. He was paying. He is ready to pay even for the daughter Ahilya. He has been directed to pay 20,000 as well as all the education expenses. We have no qualms with that. We are ready to pay for the daughter. Even with respect to the son, the family court has left it to his discretion. He has not said that he is not entitled to or he is not liable to pay.
Petition in this at this stage, There is no discretion at
Your
this
lady-
stage. That too, in the facts and circumstances where father wants a custody of the child.
Right.
In those circumstances, whether he is claiming whether he is a biological father or
I am
not,
not shying away from my
so
responsibilities, Your
then
Ladyship.
we have to
My
modify the
my
order.
my objection to the claim of maintenance is qua the claim of the petitioner to the maintenance. I do not have any dispute with the maintenance to be granted to the children. I was
Or
asked
you-
before
you
the
are
family
saying-
judge also.
You are saying that she is living in adultery.
She's living in adultery.
Then that has to be proved.
I have a judgment to support my argument, Your Ladyship.
Pass on.
Yes.
Yes.
Your Ladyship may have the judgment number 7 of the compilation at page number 38. It's Perumal versus Saraswati, Madras High Court 2021.
Please show some judgment of the this court or the Supreme Court first.
Your Ladyship, this is only with respect to the fact that when an allegation of adultery is raised by the husband and the wife is seeking maintenance, then this
Because why I do not want to look at the judgment is my view on that is different. So anyhow, that judgment
Your
is not
Ladyship,
binding
I
on
can
the
at
court.
least show the judgment to Your Ladyship. Your
Okay,
Ladyship may not consider it. I can show
Let's
it.
not. I understand. You told what it is. Please show some judgment of this court or the Hon'ble Apex Court.
Your
where
Ladyship
they
may
said-
have the judgment number 6, Shanta Kumari versus Thimagoda.
Yes. Page number 30.
Page number 30. Para number 11 and 12. Your Ladyship, I may also highlight in
Now,
any of
this judgment.
once
in the appeal.
again, I understand. The petitioner has nowhere denied the allegations of adultery. Nowhere. Not in the GWC, not in my MC case, not in the objections to filed to her MC case. She has never denied adultery or the paternity fraud. That is my argument,
denied
which I will make before
No,
the
you must
trial
have filed
court.
your objections to his
Absolutely.
MC. That you must
Absolutely.
have denied.
She's
Absolutely.
not denied, Your Ladyship.
Absolutely denied.
So that
They have not placed the GWC.
objections if you have.
I only have soft
How
copies.
can anybody not?
Absolutely.
Your
without
Ladyship,
even
that is my
looking
problem. They
No,
have not
if
placed
not-
the entire record before
Not
Your
specific
Ladyship.
denial. There would be a general denial for all the other allegations. Otherwise, how will they file their objections?
Your Ladyship, a general denial or a vague denial is no denial in the eyes of law. There has to be a specific
That will be
denial
decided by the court.
along
Please
with
come to the judgment.
para
Now,
number
this
11.
judgment is arising out of when a criminal appeal already there is a finding. So that judgment will not show me some judgment which shows that in the interlocutor when the case is at the interlocutory stage, basing on the allegations in the petition by the husband, that wife is living in adultery, she is not entitled for maintenance. Which
Your
judgment
Ladyship,
says
even
so?
the Madras High Court has not held that. Which I was only saying the Madras High Court held that when there are allegations of adultery and a claim of maintenance by the wife, both have to be adjudicated simultaneously. This was my argument before the family court also.
It can't be. Interlocutory application can't be. The purpose of giving
Because
maintenance-
if at a later stage adultery is proved against her and I have been at this stage asked to pay maintenance to her, then
court will pass an order to return that money. I'll record that.
all right, Your Ladyship. But Your Ladyship, if Your Ladyship is remanding the matter back before the family court for adjudication on the merits, then Your Ladyship may do so, and we may have the adjudication in a time-bound manner. If
1 month.
1 month is fine, Your Ladyship.
Yes. Agreed with the orders passed in. I number 2. In MC 990 of 2023 club with MC number 1487 of 2023 dated 2nd August 2025, whereby the court had granted maintenance to the daughter and denied to the son and the wife. They are before this court. The wife had filed MC number
990 of 2020.
990 of 2023 seeking divorce on the ground of cruelty. Husband has filed MC number 1487 of 2023 seeking divorce on the ground of adultery. The respondent herein, husband, has filed GNWC number, what is
18
that?
of 23.
18 of
23.
18 of 23, seeking custody of both the son and the daughter. In the earlier, certain orders were passed by the family court in GNWC. Where are those orders?
Not page number 140,
Certain orders.
139.
The order dated
3/1/2024.
2024 reveals that, as per the order dated 3/1/2024, the learned judge observed that the judge has interacted with the children. Both the son and daughter are residing with the mother. They have no problem to meet the father and spend quality time with him, but they want to they continue. They want to stay with the mother. Court also observed that the father is ready to bear the expenses of his children and also reimburse the school fees paid by the mother.
Next 13/24. Next page 141.
In 141, by order dated 11/3/2024, the court has observed that the advocate for the petitioner submits that is, advocate for the father submits that his client will pay the school fees and also arrears within 2 weeks. In the earlier round of litigation, when a writ petition has come up before this court,
155. Next year G 155.
when the petition has come up before this court, that is WP number 11119 of 2025, where the mother is before the court questioning the order passed in which IA is that?
GNWC 18 of 23, my lord.
The order passed in the GNWC dated 1/3/2025. This court has disposed of the same by order dated 29th April 2025.
It's IA
By-
number 3, Your Ladyship, in GWC.
I number 3. I number 3 in GNWC number. This court has disposed of it. So and so order. As per the following order, 159, operative portion. To extract the operative portion at 159.
May I also request, my lord, page 157, the first paragraph. On instructions, the father submits he's going to pay maintenance. Page 157, first paragraph.
No, this court has passed an order as follows. Entire order extract, 156 to so and so. After the orders were passed by this court, the family court had passed an order impugned, whereby the maintenance is denied to the daughter, the son, and the wife.
Not the daughter, Your Ladyship.
Son and the wife. The reasons that are given by the family court for denying the maintenance to both the wife and the son are that the husband has raised serious allegations of adultery against the wife. According to him, the son, he is not the biological father to the boy, and the wife is living in adultery. Along with his application, along with this petition, he has filed 3 reports, lab reports, to show that he is not the biological father.
Amongst other medical documents.
Amongst the other medical documents, the court has observed that when the father is raising the serious issue of adultery, and that he is not the biological father to the son, the court at this stage cannot grant maintenance to the wife and the child, and accordingly ordered the father to pay the educational and expenses of his daughter from the present academic year and maintenance from the date of 1/3/2025.
Though the application was filed in 2022, 23 itself.
The affidavit of assets and liabilities was filed by the wife on 1st March 25 despite multiple directions. And in fact, in the affidavit, she stated that she has resigned from a job one day prior. On 28th of February 25, she said that she resigned from a job, and on 1st March, she filed her affidavit.
The 1/3/2025. Learned counsel appearing for the petitioner mother submits that at the stage when an IA is filed seeking interim maintenance and and basing on the allegations that are made by the father, the court cannot deny the wife the interim maintenance. It is submitted that the purpose of granting interim maintenance is to take care of the needs of the parties during the interregnum period. If in every case, on basing on these allegations, on any allegations made, if the court deny maintenance to the wife, that goes contrary to the purport of Section 24 of the Hindu Marriage Act. It is submitted that the father is seeking custody of the child. He wants visitation of the child. But when it comes to the maintenance, on the ground that he is not the biological father and the wife is living in adultery, the maintenance cannot be denied to the child. It is submitted that the judgment, the order impugned passed by the family court is contrary to law, contrary to the settled legal position. The wife and the daughter, son are entitled for maintenance. Next paragraph. Then counsel appearing for the respondent father submits that the documents that are all the documents that are placed before the court, that is a statement of assets and liabilities, and all the relevant documents are not placed before the court. It is submitted that all the reports show that he is not the father of the child, biological father of the boy. It is submitted that though the MC is filed in the year 20, it is submitted that the MC is filed in the year 2023. After repeated directions by the court, the statement of assets and liabilities are filed on 1/3/2025. As such, the court had directed the father from 1/3/2025. It is submitted that as he was not aware of the fact that the wife is living in adultery and he was taking care of the child right from
2013, he was born in 2013.
2013 to 2022, he has a love and affection on the child. As such, he has sought for the custody as well as the station rights of the children. It is submitted by the council that the children are very affectionate towards the father. Towards the father. Further, when there are grave allegations of adultery, and in the light of the several documents that are placed, the court had rightly held that the wife is not entitled for wife and the child are not wife is not entitled for maintenance. Shall record that you are not denying your liability as far as child is concerned. Son is.
He is also asking that the order which was passed by your leadership in April 25 with respect to the mediation, with respect to visitation, is not being complied in letter and spirit. So,
What is that I asked and what is that he is saying?
sorry.
I think I'm very loud. For everything you're saying, sorry to repeat me, everything I said. I'm asking, you said he has no problem to take care of the child.
Yes,
The boy. Shall I record it or not?
it is up to your leadership. If your leadership
It
deems
is
appropriate.
submitted that the father father is also present before the court, and in his presence, a submission is made by the counsel appearing for the father that he is not going away from the responsibility of maintaining the child. That is the boy. He is only against granting of maintenance to the wife. So it is submitted if she had placed before this court several judgments. All right, all this citations. So judgments to say, to substantiate her argument that the daughter, that the wife, that when there are serious allegations of adultery, then the wife the wife is not entitled for maintenance. Next part.
Your ladyship may also record that my submission which I'd made, that when there are relying on the Madras High Court judgment, that this is the submission which I've made, then when there are allegations of adultery and a claim of maintenance, both should be
All the judgments were extracted. And submitted that the order and submits that the order court has passed a reasoned order. And no interference is called for. Next para. Having heard the counsels on either side, there is a material on record. First, coming to the aspect, when there are allegations of adultery, and basing on that, when the husband files a MC for divorce, whether the wife is entitled for interim maintenance. At the stage of interim application, the allegations with regard to the adultery cannot be decided by the court as it requires evidence, and that is the whole basis for granting divorce. In this case, he is relying on certain reports, and the report itself contains that the origin of the samples is not they are not confirming the same, as the same were not done with any order of the court. As such, those documents cannot be taken into consideration at this stage. Hence, the court cannot go into the allegations of adultery at this stage.
Paragraph 8, Supreme Court noted exactly what your lordship is saying. Paragraph 8.
In his contentions, he relies on the judgment of the court in Amarjeet Kaur versus Harbhajan Singh and another, reported in 2003, 10 SCC 228. He relied on paragraph number 8 of the judgment. This you extract the judgment. What did you write? Yeah, go to this. At this stage, and the court cannot deny the maintenance to the wife. Particularly in this case, where the father is seeking the custody of the child and also seeking visitation, and when he has made in the preceding paragraphs, this court has discussed about the order that is passed by the family court on the submission made by the council that he is ready to pay the take care of the maintenance of the children. The court ought not to have denied maintenance to the child, and the entitlement of the maintenance of the wife's maintenance also has to be considered by the court. At this stage, this court is not in a position to decide the same, as the court has not discussed with regard to the statement of assets and liabilities of the respective parties, but court has gone more on the aspect of maintainability. Maintainability. As far as the son is concerned, there is nothing to. As far as the son is concerned, already as per the order passed by the court, the order as granted to the daughter will also apply to the son.
No, 20,000. From this year onwards, educational expenses, all the past, the court is not awarded. Educational expenses only from the year 25-26.
Why did you not file your statement?
No, I have filed a statement of assets and liabilities in a domestic violence case in June 2023, where he is a party.
No, it is not that you are seeking maintenance in this case.
True, but in that case also I sought maintenance.
That is
the very same affidavit is filed over there also.
That will be decided by the court in that case.
Yes.
No, as far as unless and until you file your statement of assets and liabilities, court cannot decide it.
True, my lord. No, because there were other applications pending between the parties, those were being adjudicated.
Same court.
Same court, my lord. I filed, kindly see IA number 10, 11, 12, 14, contempt application for him to produce documents, all applications are before this court, family court only, my lord. So I have produced those orders also. First, he violated, my lord, the order where he had undertook to pay the
When
education.
did you file your statement of assessor liabilities?
In the domestic violence court in 2023 itself, in June 2023.
Still, they did not file it before the family
No,
court.
because
for
here I am
2
filing
years.
applications, my lord, one to strike off his defense,
Domestic violence court is not the family court.
not family court.
That's what I'm
Magistrate.
saying. So, family, before the family
Yes,
court,
my lord.
in the IA, unless and until you file your statement of assessor
Yes.
liabilities, court cannot decide.
Correct. No, but I had filed other applications, my lord, to strike off his defense because he had violated the order of the court passed in 2020.
It's a different aspect. Now, without filing your statement of assessor liabilities, how do you expect the court to decide your application?
No, what happens is this.
Your lapses, we can't attribute it to the
His
husband.
undertaking given on 1st of January 2024, my lord, 1.5 years, 1st of March 2024,
What
for
do you-
educational expenses is
In
pending.
the GWC
Yes.
case.
The court has passed an order that the daughter is entitled for the father has to take the educational expenses from the academic year 2025-26 and maintenance from the date 1/3/2025. No doubt, the statement of assets and liabilities were filed on 1/3/2025. But in this case, there is a
Your Ladyship, may I just
1 minute,
submit?
1 minute you can, it every time if you people interfere, it's difficult for me to complete the order.
139.
That he has given an undertaking before the court on 3/1/2024 that he is ready to bear the expenses of the children and also reimburse the school fees paid by the mother. As far as considering this undertaking given before the court, the father is liable to pay the school fees, reimburse the school fees from 3/1/2024 and shall continue to pay, and also the maintenance of the children from 3/1/2024. Then coming to the application of the wife seeking maintenance, as she has filed her statement of assets and liabilities on 1/3/2025, she is entitled for whatever the amount that's going to be decided by the court, she is entitled from 1/3/2025. Accordingly, this court is passing the following
Your,
order.
Your Ladyship, may I just submit? Two submissions. One, the 2.5 lakhs payment, which was ordered by Your Ladyship in April 25, was on the basis of the 3rd Jan 24 order itself. So he can't be relying on the same order asking for maintenance twice.
The if already if any amount is paid before the order, if any amount is paid as per the orders, as per the earlier orders of the court, the same shall be deducted. Next one. Accordingly, this court is passing the following order.
And-
The order dated so and so passed by the family court is modified, and both the children are entitled for the maintenance and educational expenses from the father from 3/1/2024. Number two, if any, as per the earlier orders passed by the court, if any amount is paid for the father,
Your Ladyship may record that I've paid 2.5 lakhs in April/May
we
20.
do it. It's already done as per the order of the.
We've
earlier
complied
orders.
with the order.
If any amounts are paid by the father, the same shall be deducted, and the amounts, the remaining amount shall be paid. Next two, the wife is entitled for interim maintenance, and with regard to her entitlement, the court shall decide the same, basing on the statement of assets and liabilities within a period of 1 month from the date and educational expenses, and they are entitled for the maintenance. Maintenance amount is not determined.
Not for the daughter, 20,000 rupees. I have challenged that also, my lord, because their activities itself are far more than 20. So the quantum for the children also
Where
have
is that?
Your
20,000 rupees for the.
Then, as far as the monthly maintenance of the children is concerned, and the wife's entitlement, the court shall decide afresh by giving opportunity to both the parties within a period of 1 month from the date of receipt of the copy of the order. As far as the wife's entitlement for maintenance is concerned, it shall be from 1/3/2025.
Your Ladyship,
Till number 7.
for the son and the daughter, the same cannot be equated as the son is on a 100% scholarship. That is one aspect.
That's to be decided by the
So
family.
that question can be left open.
Whatever
And
is the
second-
amount, whatever is the amount paid, whatever is the receipts, basing on that you will pay.
Secondly, the proportionality in which both the parents are liable to maintain the children. That question should also be left open if your ladyship may record that. Because
family
your
court will-
ladyship, that is a settled law that both the parents are,
Okay, the cause list is there in that.
your ladyship may record that.
Cannot go back on your concession made before the court.
Your ladyship, but that was my argument before the family court as well. This is not a new
Yes,
argument
next.
which is being made here.
17 addition.
Your ladyship may at least record my submission to that effect. If your ladyship is not recording in the order, your ladyship may record it in the submission.
Yes.
Paper petitioner. Which other is the wife? Right,
There is a
application, petition IA number 18 is filed by the wife. Right,
Where
annexure
is,
L,
which
page
page
number,
is the order?
page number 68, ma'am. Annexure L. The order passed on IA number 18. Right, IA number 18 was filed seeking recall of the order dated 2/7/2024. That is page number, my lord, 89.